Good evening. This is Laws 11059, Statutory Interpretation. This is John Milburn. It's week 3 in term 3, 2016, and we're in catch-up mode. Tonight, I want to start by sharing some websites that I think are of particular value. And to do that, I need to share my screen. For those of you who have provided information on UCrew, thank you very much. And I believe the first of these was provided by one of you, and I liked it. So I'm just going to bring up now ComLaw, and it's the A to Z of key jargon. So that's a great website in terms of getting an idea of the way in which ComLaw works and speaks. And I'll just ask a favour, if you have not muted your microphone, I'll get you to do that. There's a little bit of background noise coming through. So so that's legislation.gov.au/content/what is it. So that's ComLaw, and I think that's on UCrew. So I'm not sure whoever that was, but thank you very much. The next is, and you can own up to being the person who did it if you wish. Next one is the Queensland Legislation Handbook. Again, I think someone made reference to this in class. I appreciate it. It's something I've looked at before. It's really useful, particularly in this topic of statutory interpretation. So you have a chance to consider what is the context of legislation, the policy development of a bill, that drafting process and the parliamentary process, and then some comments about royal assent and subordinate legislation. What is interesting is down the bottom, you'll see some fundamental legislative principles, and that is useful when it comes to a drafting statutory interpretation perspective. So all of that is great. So that's Department of Premier and Cabinet, Queensland Government. So you'll find that under premiers.qld.gov.au/publications/categories/policies and codes/handbooks/legislation.handbook. Okay, so if you've contributed that, thank you very much. And one final one is the Office of Parliamentary Counsel. And no, I can't get it open. So, sorry, I tested it before and it worked just fine, but it's not working for me now. So that's the Office of Parliamentary Counsel, is worth a look. And I'll try to find that website and provide it to you. I'll just actually see if I've got the hyperlink here, unless I copied the wrong hyperlink. No, I'll check that out. My apologies. I'll stop the share now. What I want to do now is have a look at some of the weekly exercises. For those of you that have been contributing each week, thank you very much. I'm going to ask if you could turn your mind back now to week 1 and question 1. You can follow this. If you've provided a response, you may have kept your response, or we can have a look on the website. So tonight I want to go through the weekly problems. The first from week 1 is the tutorial question in relation to a piece of legislation from your own state or the Commonwealth, which relates to privacy in some way, and we're to find the purpose of that legislation, or the purpose of provision rather of the legislation. And then there's a quote about spectrum of judicial opinion and a discussion about statutory interpretation. So I'll share the screen once again, and you should see now where that's drawn, and I'll drag across the first question. So I'm giving you a chance here to remember this and think about what answer you had provided to that question. Okay, so firstly, can I have some volunteers to tell me about the piece of privacy legislation that they found? Thank you.
I think I just found a Queensland Privacy Act.
Probably.
I'm not sure. I don't really remember though. Sorry.
Yeah, there are a couple of privacy acts, if you like, in Queensland. One popular one that I saw a few times was the Information Privacy Act, 2009. Does anyone have their notes? Perhaps
Yes.
what I can do. Yes. Do you want to tell us about that?
Mine was Queensland, and I found the Information Privacy Act 2009.
Yep.
And the purpose of provision is to provide for 1A, the fair collection and handling in the public sector environment of personal information, and B, a right to access to an amendment of personal information in the government's possession or under the government's control, unless on balance it is contrary to the public interest to give the access or allow the information to be amended.
Okay. And I'm going to cheat here and just go through Ostley to find that. And that was section 3, I think you said, was the object of that act.
Yes.
Okay. Now, I know it was a popular one. Does anyone disagree with that assessment? Or does anyone have any further thoughts about where we can find something to do with the purposive provision of the legislation? So there's the section, that's the object that I think you were just mentioning. Are there any other thoughts about where we can go to consider the purpose of that piece of legislation, for example? All right. What about this one, the long title? Maybe it tells us something about the purpose of the legislation. And I'm not sure if you can read that, but it says that the Information Privacy Act 2009 is an act to provide safeguards for the handling of personal information in the public sector environment and to allow access to an amendment of personal information. So I think that provides some indication of the purpose. Where else might we look to think about the purpose of legislation? Not necessarily in the Act, but more broadly now. Any volunteers? Stop the share for a sec.
We could look towards the second reading speech or the explanatory memorandum.
Exactly. Thank you very much, Nick. Appreciate that. Does everyone know what we mean by that second reading speech and the explanatory memorandum? If you don't, just ask. All right. So thank you, Nick. Are there any other places where we can look? All right, they're the main ones. How do you access the reading speeches? Who records them?
It's within the state parliament website. I'm in New South Wales, so I couldn't speak specifically for Queensland, but there's a very good system there where you can pick an act, and that'll give you a spiel on all the reading speeches, explanatory memoranda, any other amendments when it's been through and sent back down and up from each house, plus all the dates for sent, dates of passing, and everything.
Excellent. No, thank you, Nick. And there is a Queensland counterpart to that effect as well. I'm not going to show you that website. I want you to all find that. It's really important that you know where to find the explanatory memorandum. And Alan, where does that information come from? Who records the reading speeches?
John, that's Hansard, and it's a permanent record that's searchable as well.
Excellent. Thank you, Alan. And I think from memory, on the website, there is a short video that I prepared some time ago telling you how to access Hansard records. So if that's not there, please remind me and I'll pop it on to Moodle. So thank you very much, Nick, Alan and others for your contribution there. Does anyone else want to make any comment about that first question for the week 1 assessment, the first part of it? So just in summary, you've got the long title, you've got the object of the Act, which was section 3 in that case, the explanatory notes or memorandum, the second reading speech. What about Commonwealth? Does anyone have any views about Commonwealth privacy legislation?
Yes, John, I said the Privacy Act 1988. That's a Commonwealth piece of legislation.
And Susie, from memory, you work in that field.
I work in the tax office, yes. So we have to be very mindful of privacy of taxpayers. So we learn about that Privacy Act as soon as we start in the tax office.
Thank you. So there are, of course, as Susie said, very strict rules that apply in that regard. And Susie or anyone else, in that Commonwealth legislation, where do we find the object of the Act?
I've got the object written down, but I can't remember what section it was.
Okay. And I think, so it's just called the Privacy Act, isn't it?
Privacy Act 1988 it's called, yeah.
Okay. And I think someone else said, was it you, Grace, said Privacy Act? And I said, oh no, it's Information to Privacy. I was thinking the state rather than the Commonwealth, so my apologies. So if we look there at section 2A, we see the objects of that Act set out. So really that is another example of where we can see the purposive provision of the legislation coming through directly in the object of the Act. Out of interest, Note Up doesn't really work for the Commonwealth. I'm just trying Note Up out of interest. No, it doesn't work on the Commonwealth sphere. We talked about Note Up in intro. Note Up's a great way to access case law in relation to certain things. Okay, thank you for that. Yes.
Is that in relation to all Commonwealth Acts or just for that particular one?
Look, I don't think I've succeeded in finding anything in Note Up to do with Commonwealth legislation. That's in Austlii. I stand to be corrected, but you know, if there was going to be anything anywhere, say the Crimes Act Section 21 should have material, but I don't think it does. But there are other websites that can provide good information. Let's make it an exercise this week, and I'm doing this on the run. Let's make it an exercise this week. If you come across a good website which provides information about legal research, let's pop it on UCrew and we'll share that information. Okay, the next part of the question was to do with the spectrum of judicial opinion, and a quote from Justice Spiegelman. So if you can recall, what we were after in that exercise is your comment in relation to what Justice Spiegelman referred to as the spectrum of judicial opinion on how statutes should be interpreted. So what does all that mean? Any thoughts? And if you want a refresher, just call out your name and I'll go to your answer. Everyone had an answer. It was good. Well, lots of people did.
I don't know how right this is, but I said Justice Spielman's reference to spectrum of judicial opinion is that there is room for judges to shed their own light on the interpretation of statutes, although they cannot completely ignore the law according to their beliefs, if they have a strong belief or something, and change it to one of their opinion. But they may approach the law in the way they see fit.
Yep.
So things can almost be manipulated in a roundabout way. I'm not too sure.
Yeah, no, that's fine. And I guess you're right in the sense that that quote just goes to show how many different ways there are at looking at the question of judicial or statutory interpretation from the judiciary. So thank you, Grace. Anyone else wish to provide a comment? All right, so I think someone wrote down, and I like this one, there's no right or wrong answer, and the spectrum referred to confirms that there is a wide discretion, and it changes. The way in which the courts look at the interpretation of statutes now is different to the way in which it was previously. The third part of the question relates to the separation of powers, and the question was discuss the role of the courts in statutory interpretation, and why is it limited by the separation of powers doctrine? Does anyone wish to offer something there? Now, Alan, do you want to have a look at something? And you may have volunteered that for the last part.
Yeah, that was the last part, John. I've forgotten what I said and I can't find what I've written.
Okay, there are a lot of names here. It's good. I'm just looking to see where your name is, Alan. If you see it, let me know.
I hope I'm there.
It'll be there somewhere. There were a few that I think responded to an initial post from Melissa, so it might even be there as well. Well, just generally, can I ask this? What do we mean by the separation of powers? Let's start with that. What does that mean?
There's the Parliament, the executive, no, sorry, I've got it written down. Yeah, the executive and the judiciary. So obviously the Parliament makes the laws and legislation, but it's limited to the courts now because the law is following legislation, not common law. So they possibly don't have as much freedom as what they once would have within the courts.
I think, yeah, you're definitely right. You've got the three elements there, and the emphasis has changed over the years. Thank you for that contribution, Grace. Does anyone else want to say anything about the separation of powers?
Could I throw in, please, John?
Yes, Nick.
So I think one of the key things with the separation of powers is you've got that muddiness between the executive and the legislature, but the judiciary's tried to keep itself very separate. So I think in terms of statutory interpretation, there's a real push, a lot, I guess, almost a stubbornness from the High Court not to do the legislature's job for them, which I think has some effect on it.
Absolutely. No, I agree with that. The High Court has a special place in all of this in that it has a greater power to reason by analogy and provide guidance where it views the laws as being perhaps absurd. And that is much less the case as we progress down the judicial hierarchy, if I can use that term. All right, but you're right. The judiciary does see itself correctly, necessarily, as quite distinct and the most distinct of the three powers. The Parliament and the executive are much more closely aligned. The judiciary is quite separate. Okay, so some really good answers there. I appreciate that. Unless anyone has anything further they wish to say, we might move on to week 2. And question 2 was in relation to the Commonwealth Acts Interpretation Act of 1901, and we were trying to find the Simplified Outline and Section 15C and talk about that in conjunction with the decision of Commissioner of Taxation against Stone. So dig out your notes if you've still got them, and I will now share the screen and we'll have a look at that second problem from week 2. You should see the screen there now. Scrolling down to week 2. The question I've just outlined, I'll go straight into the discussion area. And again, good number of people responding. Not as many, but still a good number. So thank you if you've responded. That's great. Now, does anyone see their name, wish to offer a suggestion as to the Commonwealth Acts Interpretation Act and Section 15C? Don't be shy. All right. Section 15C, Commonwealth Acts Interpretation Act, we'll have a look at, we'll go through Ostley. The reason I'm saying we're going through Ostley that's cheating is it's the unauthorised version. When you're in court, you're not supposed to hand up cases that are sourced through Ostley. You're supposed to do this through the authorised sources. So I think we're looking at the Acts Interpretation Act, 1901, and we're looking for the Simplified Outline. Can anyone tell me where to find the Simplified Outline of the Act? We're going to get you talking.
1A.
Thank you. And on the screen that I've got, I can't see who was saying that, but whoever it was, thank you. Who was that?
Sharon.
Thank you very much, Sharon. So 1A is the Simplified Outline of the Act. Section 15C, of course, is pretty easy to find. Go back to table 15C. Deals with the jurisdiction of the, section 15 deals with the jurisdiction of the courts. Okay, now tell me about Commissioner for Taxation and Stone. Does anyone have any thoughts on how that case was relevant to this discussion? Can anyone tell me what that case was about? I'll stop the share for a sec. Can anyone remember Commissioner of Taxation and Stone?
Yeah, I read that case. That was Joanna Stone was a police officer, but in her spare time she was a javelin thrower, and in one particular year of income she received quite a bit of money from her javelin throwing, from prize money and grants and sponsorship money, I think, appearance fees and stuff. So the question was whether she was running a business of javelin throwing, whether that was business income. So the interpretation issue was what is business income, or was this assessable income? Was she running a business?
Spot on. I like all of that. Thank you very much, Susie. And that's exactly what went to the High Court. One of the things that was relevant to statutory interpretation is the fact that by this stage, the Parliament had attempted to simplify the legislation. Can anyone tell me what Justice Kirby said about that attempt by Parliament to simplify the legislation?
It made it more complex, and it does. Every day we've got 2 tax acts, both of them are huge, and no one's ever been able to get it right. And trying to simplify it has just made it a lot more complicated. Because now you've got to consider 2 acts, not just one.
The exact words Justice Kirby said was, to some extent, it has complicated matters by the need to reconcile the 1997 Act and the 1936 Act. In particular circumstances, of which this is one, the consequence of the supposed simplification has been to produce an additional complication.
So what we see from that decision, and you're both right, thank you Susie and Grace, is a situation where it's not enough just to look at the words of the legislation and apply their ordinary meaning. We have to consider the words in the legislation from a statutory interpretation perspective within the context of the Act as a whole, and even worse than that, we have to consider the words within that Act in the context of what those words replaced from previous legislation, where the courts will assume that the attempt from Parliament was to simplify but not necessarily change the meaning of what had been established in earlier legislation. Does everyone agree with what I've just said? Are there any thoughts? You can disagree. You know what's good about law? You can disagree and be 100% wrong and get 100% right on your assessment. Does that make sense? In other words, in the High Court, you have 7 judges considering the same facts, hearing the same evidence. 4 of them decide one way, the other 3 decide completely opposite result. We're not going to say that those 3 got it completely wrong and their opinion is worth nothing. They could still get 100% in an assessment. Does that make sense?
Yeah. I have a question. With the Commissioner of Taxation versus Stone, with that piece of legislation that they were referring to that had been simplified, would that mean that they had repealed that, or that they had amended that act? I can't hear you.
Yes, sorry. Yeah, look, it was a brand new act, but it had the effect of amending the earlier legislation. So it was a very substantial amendment to the act.
Yeah.
Okay, now if you're going to have a look at that decision, have a look at paragraph 102. Justice Kirby said, made some comments there about why, in fact, the ATO should win that case, even though there were some concerns about the actual motivation for doing so. Look, another place that you can look sometimes is to go to commentaries, and in that case of Stone, there was actually a commentary from the ATO, which is valuable. So keep in mind that places like the ATO have databases which can provide some real insight. And there you see some comments in relation to Federal Commissioner of Taxation and Stone and some tax rulings. So that's a useful place to look at. All right. And you're looking at me, aren't you? Not the screen that I'm referring to. I'll share the screen so you can actually see what I'm talking about. And there it is. Taxation ruling, legal database from the ATO. And that sort of thing can be very valuable. Okay, so what we talked about in that Commonwealth legislation is the overview, the simplified outline, section 1A. We had a look at the jurisdiction of the courts, section 15, cap C, and we've discussed that decision of Stone. I'll stop the share now. Now, the second question for week 2, if you can cast your mind back to that, related to, and I'll just read it to you, locate the best online site to find the following for your state and then for the Commonwealth Parliament: explanatory memorandum for new bills, and second reading speeches. Now, who would like to volunteer? Jay, thank you very much. You've given us some details. Do you want to speak to that while I call it up on the screen, Jay?
Yeah, I just went to the Queensland Parliament website and basically trawled down through the basic, the work of the Assembly bills, the legislation before the House, and it's all listed down there on the right-hand side. You've got the bill, the explanatory speech, the second readings, etc. So basically, just Queensland Parliament.
Okay.
To work.
Thanks, Jay. So that's what you were looking at? That's what you were...
Yes, that's the one.
Okay, so federal legislation, and you've got there the Acts Interpretation Act with lots of other valuable information.
Yep.
Legislative instruments, notifiable instruments, gazettes, bills, other. So that's a really good website to go to, legislation.gov.au. Thank you very much for that. Does anyone else have any websites that they would like to proffer as being worthwhile? So that's That's a Commonwealth one. Any others? I'll stop the share for a moment. So the site was, oh, you've got it, Shay? All right. Are there any other websites that, we're going to share these on the UCrew. So Jay, thank you. If you would volunteer to put that on UCrew, that would be great. Any others? All right, I'm just going to give you this one. I'll call it up onto the screen. I'll remember to share the screen this time. You should now see Parliament of Australia, aph.gov.au, and that's a useful place to look as well, giving you good information about the process and up-to-date information. All right, so there's a couple from the Commonwealth sphere. So that's aph.gov.au. From a Queensland perspective, let's see if we can find one that, there we go, Queensland Parliament. And we have the work of the Assembly, the homepage for Queensland Parliament, and lots of good information there. So that's parliament.qld.gov.au. All right, and there's more than that. There's other websites. So let's share those and make it collaborative and easier for everyone. Okay, now the third question in week 2 related to Coleman and Power. Let's go back to, they're the people that provided a response. Thank you for doing so. Coleman and Power, the quote from Justice Kirby was, if the parties do not address the interpretation point in argument, many do, that is their choice. It is not the judicial obligation to put specifically to parties, least of all well-resourced government parties, every rule of statutory construction relevant to the performance of the judicial task. What does that mean? Does anyone wish to make any comment?
That the term many do isn't assumed knowledge of the judiciary for every point made by the parties. So it should therefore not be expected of Her Honour to ask if many do. If something is open to interpretation, that it could be that many do something. And it would benefit them in saying that the judge doesn't necessarily, it's not her responsibility to ask, it's the responsibility of the parties, because that's all time consuming. So the parties need to state that if it is of importance to the argument. That's what I thought.
Okay, thank you, Grace. Excellent. Any other thoughts on Coleman and Power? And you can ask me to open up your page, your answer, if you like.
I'd be happy to share my answer, John. It's Monique.
Thanks,
It is
Monique.
on there.
Well, while you're talking, I'll try and find it. Yep, I've got it.
I noticed I missed out. Oh, sorry, I missed out a word in there. It doesn't make complete sense. So.
Oh, that's right. You can speak to it. So, can you see that up on the page now?
Yep.
All right. Perhaps you'd like to tell us about that one.
Okay. So I felt that the statement meant in future my role as a solicitor or advocate, I need to ensure that I'd explored all the interpretive options that may be relevant, obviously prior to presenting in court, because it's not the role of the court to do that, but rather the role of the legal professional.
Yep. Thank you very much, Monique. That's good. Are there any other thoughts on Coleman and Power? Appreciate those contributions. Yep, thank you.
Yes, please feel free to open mine. I'm Vivian Khan.
Hi, Vivia. Now, let's see if I can go back to yours. Can you see your name there?
Yes.
Whereabouts are we?
today 6-5. The second one.
Second one, Vivian. Okay.
Yes.
All right, and there we go. Coleman and Power. So what does all that mean?
Well, to me, it means that if I'm arguing a case, I'm not absolutely bound to utilize every rule of statutory construction relevant to my performance as a lawyer in any case scenario. It's my choice to address or not to address the interpretive point in my legal argument. That means the performance of my judicial task will not be diminished, even if I choose not to address every rule of statutory construction in my legal argument.
Okay, that's great. Thank you very much. So I really appreciate the contributions there. I think it was Grace and Monique and Vivian. So appreciate all that. And I take from that in this instance, the role of the lawyer is to advance certain arguments. I take your point, you don't have to advance every argument. There's a lot to be said as an advocate in advancing your primary argument and making that important. Also, bear in mind that even though there are two arguments presented to a court, I think what Justice Kirby is saying is the court doesn't have to choose between those. The court can come up with its own solution and variation as well. So there are a few different ways of looking at that quote, and I think they're all correct. So thank you very much for that contribution. Now let's move on to week 3. And this week we had to consider generic provisions in relation to age, gender, number, etc., and discuss those generic provisions in the context of a lease. It wasn't an easy exercise. So let's have a look at week 3 discussions. We'll pan down. We'll see how many students have contributed this week. We'll go straight to the responses. Now it's looking a bit sad now, looking a little bit sad. Bear in mind that we do want you to have your responses in before we get to this tutorial. Thank you, and I'll name them. Dominic, Sharon, Shireen, Monique, Leonie, and Sarah. Thank you very much. And those of you that are about to lodge yours, I'm sorry. You can still do that. Does anyone want to talk to me about the generic provisions in relation to age, gender, number in the context of a lease for a new building? What does all that mean? And while you're thinking about that, Jay was absolutely correct. He advanced an opinion about the last answer that was pretty much what I said. So thanks for that, Jay. All right, so back to this. What do we mean by these generic provisions? What is all that? Where does that come from?
John, may I ask a question, please?
Mm-hmm.
It's Monique. When I was doing the exercises for this week, I was a little bit confused where generic provisions were referred to and whether or not that only covered things such as age, gender, time, distance, and those that were mentioned, or whether that expanded to include provisions specific to a particular piece of legislation or lease, you know, in the example.
No, really good question. Yep, absolutely. Well, firstly, can I ask this generally of people, where do we find these generic provisions? Are they part of case law? Are they part of statute law? Or are they something different?
I think you'd find them everywhere, wouldn't you? Or
You'd find them in different places, but I guess the emphasis in this week's chapter is to consider the Acts Interpretation Act, both federally and state. And you'll see some interesting provisions there in relation to those provisions. So I don't know, I'll just pick up our text, and if you flick through chapter 3, you'll see dotted through that chapter reference to the statutory provisions, state and federal, and it's really quite interesting reading. So, for example, when we talk about generic referencing or provisions in relation to gender, have a look at section 23A of the Commonwealth Act and section 32B of the Queensland Act. And if you read those sections in conjunction with the content of the chapter, it'll give you a really good idea. And it's interesting that most of the time the states agree with what's in the Commonwealth legislation and with each other, but sometimes they don't. For example, when it comes to distance, if there's a reference, for example, to a distance in legislation, different rules apply. So on page 36 of the text, it says, if an act specifies, say, 500 kilometres from a certain place, then this distance is measured in a straight line, you know, as the crow flies, according to section 35 of the Commonwealth Act. But in Queensland, section 37, the distance is measured along the shortest road ordinarily used for travelling, unless the contrary intention is shown to have been stated as a straight line. So I guess what we're really saying is that when you see something about gender, number, distance, think in terms of what's in the Act that you're reading, but also remember to consider the Act's Interpretation Act. In terms of the answers that I saw, this I thought was a great answer of yours, Monique. I actually put it on my notes as one that I wanted to show people anyway. So thank you for your contribution there. And what you're doing is you're making it neutral in terms of age, gender, number, and it's not easy to do. It's a tough exercise because you really want to say he or she, or he/she, you know, and/or. You want to say all that because it's easier. It's harder to to draft it in that other manner. All right. So when it comes to generic provisions, it's our second question, and I'll stay on yours, Monique, because I think you've got that there. You've made reference to the Act's Interpretation Act, Queensland, and you've made reference to the Fair Work Act as well. All right. And finally, question 3 related to, and I'm sorry I've got yours up on the screen there, Monique, I hope you don't mind. Is there anyone else want to volunteer an answer to the third question?
All we can see is you, John, not Monique.
Oh, sorry. How many times have I done that tonight? 4? All right, so there we can see, I'll just go back to Monique's answer, and that was her response in relation to problem 1. Very good. Problem 2, Queensland Act's Interpretation Act, and problem 3 relates to the next question. So in relation to problem 3, the problem was about the people of Rockville who launched boats and other watercraft. The Town Council enacted a Safe Parks bylaw to stop the activity, but it was struck down by the Supreme Court as ultra vires, that is beyond the power of the Council to do that. So now Darcy asks if he can resume launching his boat. What do you say? And would it make any difference if it was a state, if it was legislation rather than a bylaw? Does anyone wish to provide a response to that? Anyone here who's got their name provided a response already? Do you mind, Sharon, if I have a look at yours?
You're right.
Thank you. So there you go. And can resume because the court declared it illegal and unenforceable. Okay, same outcome if it was state legislation. Does anyone disagree with what Sharon has said there? I agree with that statement. I think that's right. Just have a look at what Shireen said. And yep, same sort of issues there. Okay, you've been very patient tonight. It's been a long session. I'm going to stop the share now. We have our first assessment due on the 15th of December. Start working on that now. I have released that assessment. Has everyone been able to see the assessment? You know what the assessment is now?
Yes.
All right. Has everyone had a look at my sample document?
Yes.
All right. So the sample document is important if you're writing a written assessment and you know that I'm marking it. You should have a look at what I think is a good way to set it out. It doesn't matter if other people say it should be different, but bear in mind, if I'm marking it, and I will be, follow that sample document in terms of the basics. It's not prescriptive. Just because I use a certain font doesn't mean you have to use that font. There's nothing like that, but there are some basic elements of that document that I want you to take on board. I want you to be consistent with your headings and the layout. In other words, I want to look at the document and think, okay, here is a person who is soon going to be charging $400 an hour to prepare something. It's got to look right. It's got to inspire confidence in me. Otherwise, I say to myself, why am I paying this person $400 an hour to draft this material? Okay. Second thing is, you've got to follow some of the basic rules. Don't do something that makes it obvious to me that you're a novice at this. So it's got to look right, and you've got to follow some of the basic rules so as not to betray the fact that you are in first year. Does that make sense? So a professional looking document that follows some of the basics is what I'm after. And you'll see that I'm very keen on short sentences, particularly at the start. In the sample document, have a look at some of the extracts of short sentences used at the opening of a judgment by Lord Denning, who was very good at this. Okay, any questions, comments before we go? And I thank you for your patience. Yeah.
It's Sharon. I nearly asked a question an hour ago. Someone put on your crew whether you put it in a table or just, because there is an example on the internet if you search, or do we just use headings?
My personal view is that's entirely a matter for you. That's kind of a discretion thing in terms of how you present it. There is no right or wrong answer there. Whatever catches your eye as being best. But whatever you do, try to make some consistency in terms of the way in which it's presented, if that makes sense. And I always encourage people to be creative. If you think that the best way to get your point across is to use a flow chart, then use a flow chart. That'd be great. So, and that's thanks for asking that, because it really does give me an opportunity to emphasize that even though I have certain basics, I still want you to have your freedom to be individual in the way you present your material. So thank you. I hope that answers your question, Sharon.
Yes, thank you. And also with the CIC insurance, when you go to the link, it gives you like the High Court decision. How do you go back to the first case, you know, like where it all started?
One way to do that is to go through Jade Barnett, because you might, if you go, does everyone know what Jade Barnett is? Jade is, I'm not sure I've still got it up on my screen, but Jade has a really good service.
I do now.
Yeah, so Jade Barnett, and if you go into Jade Barnett, you'll actually see a subscription service where you can subscribe to get updates of legal information on a daily basis or a weekly basis, whatever you want. So that's a good way of finding the previous decision as well. But if you have the citation, you can find that case through Ostley or other places as well, generally speaking.
Yeah, but it seems to be giving me just the High Court one. So
Okay.
I don't know if I'm missing something or...
Monique has some thoughts. Monique, do you have something that you wish to add?
Sorry, I was reading through the Jamina case, and I found links to all the previous hearings at the bottom in the references. So they made quotes and points about what was said in the first initial, Land and Environment Court, and then in the New South Wales Court of Appeal. So the links were at the bottom of that same document.
Okay, thank you.
Thanks, Monique. And Monique, would you mind sharing that on UCrew?
No worries.
Thank you very much. All right. Well, look, I might end the session now. Thank you very much for your contribution. If you have any questions, please ask through UCrew. Otherwise, we'll see you next week. So all the best and bye for now.